Once again, the morning ramble didn't turn out. Whatever. I talked about State v. Kelly on it, and I may have been unclear. There are three basic lines of cases that the Connecticut court used to try to justify seizing someone who's just with someone else. The best case they had for that was the 11th Circuit case, which I didn't really go over because it's 11th Circuit and it's not Supreme Court, and Connecticut isn't in the 11th Circuit, so there you go. The first line of cases is the cars case, vehicle cases. If they seize the driver, they must necessarily seize the passenger because the passenger's in the car and they're stopping the car. That doesn't make sense because you can stop someone on the street without stopping the person next to them on the street. They're not tied together. So those lines of cases fail as far as supporting officer safety justifications for stopping another pedestrian. And also the control of the officer safety concerns that occurred after the seizure of the vehicle, like being able to tell passengers to get out and whatnot. That passenger's already been seized. So the officer safety concerns come after the seizure. The warrant cases, a magistrate has already found probable cause. So it makes sense. You don't want people walking out of the door with evidence, so it makes sense to hold them there. They are tied to that location. They are tied to the thing that the magistrate gave probable cause for. They're physically bound by it. They're within the walls. It's a limited class of people. Worst case scenario, assume sidewalks in New York during the busy hours where within 10 feet of you, maybe there's 30 people. And then think about applying this to that sort of situation. It can get a little ridiculous. Whereas in a house, if there's 30 people in a house, they're still bound. There's still like a limit, a hard limit on, the property lines or whatever. There's a hard limit to it. And the cases that the court cited weren't terribly supportive. The first case was Ibarra v. Illinois. In that case, the Supreme Court ruled that just because they were serving the warrant on the bar doesn't mean they could search the customers. The second case was the guy coming out of his own house. The third case, again, was the guy coming out of his basement. And then the final case was the Mena case, where they were looking for gang paraphernalia. They were assuming that the people in the house were gang members. They had reason, probable cause. That doesn't apply to somebody on the street. And then the final line of cases were the probation/parolees. They have limited rights. They can't own firearms. They can't leave the state. They are in the correctional system. They have limited rights. Saying that because those guys have limited rights and aren't protected as much by the Fourth Amendment should not apply to people who aren't in the correctional system. Because they have not been found guilty. Basically, the people in the correctional system are already seized. And they have reduced rights because of that seizure. Some of their rights are still withheld by the state until they're done with their probation or parole. So there you go. That's why I think those three lines of cases didn't really support it. And I don't think officer safety is a compelling reason. I think Illinois v. Wardlow is a much better rationale for a seizure in that particular circumstance. And I think they went through a lot of hoops to try to get a rationale that they didn't need to go through because they already had a real good case in Illinois v. Wardlow. All right, no opinion on the Southside Slacker arrest. I have lots of opinions on the Southside Slacker arrest. Tubby here is probably not a cop because A, he's that tubby, although in Texas I've seen some really tubby cops. So, did he assault Southside slacker, yes. 22.01A3, intentionally or knowingly cause physical contact with another when the person knows or reasonably should believe the other will regard the conduct or contact as offensive or provocative. So yeah, there was assault. It is a Class C misdemeanor. It is a very minor offense. Maximum penalty is a $500 fine. Police do have discretion on whether or not they will arrest someone or cite them for a misdemeanor or an infraction. You can roll by the police to 100 miles an hour and they don't have to chase you down and stop you. They can let you go. The police have discretion. Police have discretion in this case too. Do I think the guys who witnessed it, like this guy, is he a cop? Maybe. He may be a supervisor. He's certainly not in uniform. None of these guys are in uniform. These guys aren't in uniform. He's got a gun on his hip. He probably is a cop. But that doesn't mean that it's their role to enforce things like that. It ends up being uniformed police officers who come around to make the arrest. They do not have probable cause, I don't believe, to arrest Southside Slacker. But they may have reasonable suspicion to detain him. They may have received reports of an assault, and they go out there and they see Southside Slacker looking like a thug, acting... I mean, you listen to his language, it may be reasonable for them to assume that he is a party to the assault. He may have done the assault. I can see that. As soon as he shows them the video, they should release him. I don't know if he ever does show him the video. I don't know why he says he's not going to. I thought that was weird. He's like, yeah, they're going to let me show him the video, but no, I'm going to go ahead and keep rolling anyway instead of showing them the video. That's weird, but okay. He assumes that these other police officers saw what happened. I think the guy in the red shirt did. The guy on the left in the red shirt. You know, it would have been the right thing to do for that guy to say, no, this guy didn't do anything wrong. But, so yeah, and I don't think that Southside Slacker would have a winning lawsuit against the guy who pushed him on the assault. No damage, so you won't prove damage. Do I have more? I just checked this a second ago. I don't have more. I don't. All right. All right. So Ron asks a pertinent question. He tries hard not to, but occasionally he does. How are you not liable for slander if you have no proof they do meth? Oh, right, they need to refute your hearsay to prove their innocence. Well, if they were just private people, then maybe they wouldn't have to prove damages to get punitive. However, let's see. All the reasons why I'm not concerned about this. Number one, they would have to come to California, to the greater Sacramento area. So it may be Sacramento County or Placer County or Yolo County or Yuba County or something like that. One of those places, wherever I live, and file suit. I don't suspect tweakers are going to come out to California to file suit. Either in state court or federal court, they're going to have to come out to California. Venue is going to be appropriate out here. Personal jurisdiction is going to be appropriate out here. So, yeah, I don't suspect that tweakers are going to drive out here to sue me. So, not concerned. If they do come out here, still not concerned. I believe they are public figures. You may notice that I made my comments in response to a video that they posted in the public space. I'm going to argue that they are public figures, or if they're not fully public figures, because they're not a household name, they are at least limited public figures, i.e. for the purpose of this video, they're public figures. Which means that they would have to show actual malice. The actual malice standard means they have to show that I knew or reasonably should have known. I knew or was put on notice that I should check to see if my statements are true or not. Which in that they'd have to prove that the statement is false. So, yeah. And finally, if they do try to do anything, they're going to have to deal with the fact that I'm going to bring their video into evidence. And a judge is going to look at it and going to be like, these dudes are tweakers. And I'm going to be like, yeah, I know, they're totally tweakers, right? And he's going to be like, yeah, they're totally tweakers. Like, what are they thinking? You can't be tweaking out in a paranoid panic on YouTube and not expect someone to say, hey, you're a tweaker. And I'm going to be like, I know. And then maybe, just maybe, the judge will be like, hey, you want attorney's fees? And I'll be like, yeah, bro, maybe. I don't know. Can they pay attorney's fees? No, judge wouldn't actually offer that. And just filing the suit, I don't think attorney fees would be appropriate. But if they did anything quirky, then I may get attorney's fees. Because would I hire an attorney? Absolutely, I would. Speaking of attorneys, I had a discussion with the head attorney at my law offices. He's been practicing law longer than I've been alive. Very smart man. A discussion came up about a client was worried about potential liability for defamation. And we discussed it. I discussed it with the boss. But the boss said, you know, I've been doing this for a long time. And I said, I know. And he said, you know how many defamation cases that I've had to deal with? And I said, no. And he said, 0. Do you know why? And I said, I bet you're about to tell me, because you don't tell him why, because he likes to tell us stories. So I said, it's next to impossible to prove damages. And I said, that makes sense. And think about this. These are 2 unemployed tweakers. What kind of damages do they have from me calling them tweakers? It's harm to their reputation. They're putting out videos of them tweaking out in a paranoid panic. How am I pointing out that they're in a paranoid panic, causing them any more harm than they've already done to themselves? I'm not. And the court will believe me. So that's why I'm not worried about it. Whether or not I've actually done it, that's up to a finder of fact. I don't think I have. And I think they'd have a hell of a time proving it. But hey, you know, it'd be fun. I'd have pleadings. I'd have tweaker pleadings to show people on my videos, and that would be hilarious. Anyway, thanks for watching. Have a good day.